Happy New Year, everyone, and thank you for coming. I just wanted to remind everyone that in order to get your certificate, you should send back your signed affirmation with course code to me at dzac@judicialtitle.com. If you're not in front of a computer, we'll take a fax. You can take a picture of it and send it to me. As long as you have the course code and your signature, that's fine. Also, please fill out the evaluation that was sent. After the course, I will resend everyone the material, the affirmation, along with the evaluation link. And please feel free to ask questions in the Q&A box during the lecture, and we'll get to those at the end. Now I'm going to hand it over to Richard Gelati, President of Judicial Title, to introduce our speaker today.
Thank you, Diana. And again, thank you for all your hard work doing these CLEs. I know you put a lot of time and effort in it, and we got a great speaker for you today. I've known Toni for a lot of years. She worked for a couple title companies in her tenure, and you're in for a good treat. She knows what's going on. And Toni, last I looked, 450 people signed up for this.
Wow.
So,
those boundary line issues must be piling up.
So please make it good, great, fantastic. I know you will. And one of the quick personal note there, I noticed that you're a political science major, and I had history political science major too. And I guess we didn't know what to do with ourselves, so we come to title insurance.
That's right.
But again, I've known Toni for a lot of years. She's been a regulatory counsel for a lot of companies, a couple of companies, not a lot of companies, a couple of companies. And today we're going to talk about the boundary lines. What does Deminimis mean? Good luck with that. Our next CLE is going to be on February 10th, and that's going to be on commercial leasing updates during the pandemic. What are the new laws, and what can and can't you do now? So it's a moving target. Speaking of moving targets, and Toni, I hope you know this too, is that the New York State Land Title Association was able to pass a RIN-RON bill. It was signed by the governor on the 22nd of December. What is RIN and what is RON? Well, RIN is remote ink notary, and RON is remote online notary. So as soon as the governor signs the chapter amendment, which we expect to be end of January or beginning of February, New York will have the ability to go online and do online notaries. And it's a lot better than an executive order because people could be out of state and actually out of the country, if you really want to look at it that way. And we're going to have a third-party vendor. It's going to be a different world we live in. But New York became the 39th state to have our RIN-RON built. And so we're excited about getting that done. And again, as soon as the governor signs it, it becomes law immediately, and everybody will be getting information. So I'm going to leave you to Toni here because it's a good topic and there's a lot of information, and I'm sure you're going to have a lot of questions. And good luck, Toni.
Thank you.
Good job. Thank you. I appreciate it.
So good afternoon, everyone. And I want to thank Richard Gelati and the judicial team for trusting me with their family. And today we're going to talk about the boundary line and understanding this de minimis standard. Obviously, the case law on this and the statute changed back in 2008. This should be old stuff, but judging by the number of people on the call, which is about 450 of you, it's still confusing. And I do get the questions, so I do see the confusion. So today I'm hoping to undo some of that confusion for all of you. And I want to start by just introducing Westcor to the judicial family. We've been with Judicial shy of maybe 2 or 3 years now, and they've been an amazing partner for us as agents. Westcor, as you may or may not know, only partners with agents. We do not have a direct operations to compete with our agents. So our focus is on our agents and their needs and their clients' needs. Westcor opened its doors back in 1993 in the kitchen of our CEO's house. Mary O'Donnell is our CEO. And in New York, it opened its doors in 2008, which was it's been an amazing ride. It is grown to be the largest privately owned title company in the nation. And what does that mean for all of you out there? Look, being privately owned doesn't mean we're beholden to any shareholders, which means that we're a little bit more innovative. We take a little bit more risk. We don't have so many layers. So you get an answer to your question directly to Tony Carlos or directly to one of our underwriting counsel. We don't have to go up to, unless it's a humongous deal, to another counsel to get you an answer. Our growth has been so outstanding that a majority shareholder has just purchased an interest in Westcor. So we're very excited for that because it just means we're going to grow even bigger. And that's a good thing. So for those of you who don't know Westcor, I hope that you will give us a try through judicial. And let's move forward to our topic for today. And it is the boundary line, understanding the Deminimis standards. So we're going to go through some history. We're going to go through the statute before the change in 2008, go through some of the case law, and then go through the new statute and what its effects are. So again, let's start off with this term, out of possession. And out of possession has become a term of art in our industry. It actually means that a portion of the property is not within the control of the owner. So what's the relevance to real property transactions? Well, this thing. We never thought, I think many of us, that we would ever see this term ever again, adverse possession, because when we learned it in law school so many years ago, it was kind of barbaric, right? Who does that? Who actually takes possession of property, knowing that it's not yours, or maybe not knowing it's not yours, but still taking possession of a piece of property and gaining title to it? It just seemed very barbaric to all of us, I'm sure. And how would it actually be used? Because back when I was in law school, which was many eons ago, I never even paid attention to it back then because it really was, it seemed like it was an out of date concept, right? But as you will see, unfortunately, it's not so out of date. So let's just go through a little bit of history. The adverse possession common law dates back to when Henry VIII was the king. And back in those days, it was very acceptable for anyone to gain title to property just by sword and blood. Well, as time went on, adverse possession became a justification for acquiring property because it was it promoted productive use of the property. So it was very acceptable to many back in the 1800s to gain title to property through adverse possession. So I'm just going to remind you what the elements are, and we're going to go through the elements in greater detail as we move along to partway through this lecture. Possession has to be hostile, meaning you are actually doing something in order to take that property. Claim of right. It has to be actual, open and notorious, and exclusive for a period of, back then it was 20 years. As of 1963, it was reduced to 10 years. So courts actually applied the common law for a very long time until 1829, where these elements were codified by statute. And in a 1915 decision by the Court of Appeals, the first time the Court of Appeals heard any cases regarding adverse possession, the court was very much in clear support of the statute and actually admonished the owner of the property and said, if we are not going to protect your negligence of your property by allowing somebody else to take possession of it, so we're going to award the plaintiff the title to your property by adverse possession. So the common law, supported by the Court of Appeals or the courts of the state of New York, has been in place since 1829. Today, all 50 states have adverse possession statutes, as you can see here. New Jersey and Louisiana have the longest possession period, 30 years, and Texas has the shortest, which is 3 years. So much of the principles and the guidance that we have via adverse possession, we gain through case law, but we do obviously have relevant statutes that took what we learned, what we have in case law, and codified the same. Okay, so these elements, which are now housed in section RPAPL 5, section 501, were codified back in 1829. Not much has changed in terms of the elements of adverse possession. As you can see, 511 codified a statutory period of 10 years. And the most recent, prior to the 1829 codification, the most recent amendment to the RPAPL was back in 1962, when it codified a definition for actual and hostile, RPAPL section 512. And this is where you see they're usually cultivated or improved or protected by substantial enclosure to prove hostility or actual notice. So let's just go through some of these elements, because I think because of the case law, some of these elements are, there are some exceptions to some of these elements, and it's helpful to know. So when we talk about hostility, there must be some sort of actual taking of the land. You can't just accidentally sort of happen upon the land. You have to actually take it, which means that you had no permission, there's no consent of the landowner to which you're adversely possessing their portion of land. That means that you're the one that put up the fence as the adverse possessor. You're the one that put in the flower boxes, the driveway, or any other encroachment. It has to be your doing, okay? That's hostility. That's also actual notice that would put an owner on notice that someone is laying claim to their land. I want to note that hostility, suppose if you meet all 4 requirements of adverse possession, hostility will be presumed, okay, if you meet all the other 4 requirements. However, hostility will not be presumed if you have consent or cordial relationship with the person to whom you are adversely possessing. Actual, open, and notorious means that you're cultivating the land as if it was yours. If you have a substantial enclosure, for instance, a fence, and on the other side of the fence, which I usually get, on the other side of the fence is a wooded area or some area that would be impossible to actually cultivate, then the fence that, the fence, if you're out of possession of your piece of property and there's nothing going on the other side, then that means, you can't really meet that element of adverse possession. And this is what I kind of go through when we're asked to produce a boundary line agreement. When we ask you guys to produce a boundary line agreement, these are the questions I ask of the agent, because it's important to know, if I'm not going to require a boundary line agreement, what is the likelihood of the adverse possessor's success on the merits, right? So if I could undo one of the elements of adverse possession, and hostility is probably the easiest one, where you have consent and a cordial relationship, or where you don't have the actual hostility because you see a substantial, usual cultivation or improvement, then it becomes a moot point. And then I don't need a boundary line because I know the likelihood of success on the merits of the adverse possessor is probably close to none, right? Because all elements must be met in order for you to gain title by adverse possession. So, okay, so possession must be with exclusive for a period of 10 years. What does that mean? That means continuous. That means that you have been the owner from 2001 to 2011. That means you are there full time, 2001 to 2011. That means that if you are a new owner and you only, let's say, just purchased the property a year ago, you can tack on, if the use has been the same for the past 10 years prior by the predecessor in interest, you may tack on that time so long as you two have privity. So once all these elements are met, you have title by adverse possession. It's not a right to go to court and seek a declaration that you own by adverse possession. You actually own it. That's why when you do boundary line agreements that say, I lay no claim to this land, if you're getting a boundary line agreement from your neighbor, that really does me no good. Why? Not laying claim to the land means you're denying that you've already acquired, especially if it ripened already. That means they already own the title. They cannot now say, I don't own the property, because it's already been, the element's already been established. They own it. So what has to happen is your boundary line agreements must, and I'm going to go through this later on in the presentation, must contain language that shows consent. Okay, so the onus is on the owner to make sure that his property continues to be his, that he is exercising control over his property, and courts and the statute all show us that, right? That's where the support for adverse possession lies. Well, along comes a case called Walling versus Prisbilo, decided by the Court of Appeals in 2006. The actual case started in 2004, and it made it through to the Court of Appeals, unfortunately, through to the Court of Appeals. So what happened? I downloaded these pictures from Google Maps back in, and I think it's a 2016 picture. So these are not the actual pictures that was used back in 2006. Not quite sure if where you see P is a Prisbilo property, W is a Walling property, whether or not the Prisbilo property was vacant at the time. But what happened was, so Jeffrey and Kathleen Walling purchased 13 Butternut Hill Drive in Queensbury, New York, back in 1986. And about starting 1987, the Wallings deposited fill. They deposited topsoil on the northerly side of the Prisbilo side yard. Now, that's where you see in red. I don't know exactly that's the location. That's about the location that, based on the complaint, that I can discern. But again, this is not an accurate picture, but on or about there, they started to install trenches so that their downspouts would, redirect the water from their eaves and their downspouts, all of which were under the Prisbilo property. So but the Prisbilos did not purchase their property until 1989. So much of what the Wallings did was prior to the Prisbilos even owning their property. The Prisbilos started construction on their home back in 1991, and that was completed in 1994. I don't know why they conducted a survey, the Prisbilos conducted a survey in 2004, that the facts of the case don't really tell us that. But they conducted a survey in 2004, and they realized that the Wallings the improvements of the Wallings are on their property. Well, they commenced an action for ejectment, and the Wallings then countersued for declaration that they owned by adverse possession. And the court agreed with the Wallings and said, you know, you now own by adverse possession, you met all the elements, and the Prisbilos appealed to the appellate division. The appellate division agreed. So what the Wallings found, what the Prisbilos found really abhorrent is the fact that the Wallings admitted in their deposition that they knew that the property was not theirs. So actually I lie. The appellate division actually reversed, because they opined that the knowledge of the Wallings from the beginning as to whether or not they knew that the property was theirs would lend to, would counteract the element of hostility. Well, the appellate division said, the Court of Appeals said, absolutely not. Whether or not the Wallings had knowledge of the fact that they didn't own that property, or that they own that property, it doesn't matter. They have met all the elements of adverse possession. And if you think about it, the whole idea behind adverse possession is that you're doing something that should have put the record owner on notice that their land was being controlled. So since the Prisbilos did not do anything about it until 2004, then too bad. They already owned it. They did what they, whether or not they knew or not knew, that's not a problem. So the Prisbilos didn't like the result of the Court of Appeals case and decided that they were going to lobby their senator, who then sponsored a bill to overturn the court's decision. Eventually, the 2008 amendment was signed into law, and the resulting provisions are as follows. So 501 still has the same elements, but a claim of right, which did not exist in the original 501, means that a reasonable belief that the property belongs to the adverse possessor. Prior to the 2008 amendment, it didn't matter whether you knew or didn't know that you were the owner of that piece of property. Now you have to establish a reasonable belief that you thought you owned that property. Think about that a minute, right? How are you going to prove that you had a reasonable belief that the property belonged to you? Question, right? Did it help? I don't know. Actual possession, act sufficiently open to put a reasonably diligent owner on notice, now is in the statute. It wasn't there before, but the most significant change to RPAPL 501 and to 551 is 543. Permissive use is now defined as de minimis, non-structural encroachment, such as fences, hedges, shrubbery, planting, sheds, non-structural walls, lawn mowing. So anytime we have these minor encroachments, we cannot use these as evidence of hostility or evidence of actual open notorious, right? So it's much more difficult to prove an adverse possession claim, right? Because most of the issues arising that we're concerned about here concern fences, hedges, shrubberies, plantings, driveways, sheds, non-structural walls, lawn mowing, right? So did it fix it? Well, this is also much of the reason why it's a problem. Shall be effective immediately and shall apply to any claims filed on or after such effective date. The effective date of this statute is July 7th, 2008. So as of July 7th, 2008, that means the new law applies. So any de minimis, right? That means any of these de minimis non-structural encroachments, we can just disregard that. We don't need boundary line agreements. We're free. We're free. No, you're not. No, you're not, unfortunately. And, you know, it confused the courts as well. And much of the case law after 2008 actually centered on when does this statute actually apply. In the second department, which we are in, Hartman versus Gold applied the new law. The Hartmans believe they own a strip of land based upon a 1987 survey and that they obtained when they built their home. They installed a drainage system, driveway lights, planted shrubs, landscape, and the appellate division affirmed the lower court decision granting summary judgment to the defendants, the Goldmans. The appellate division agreed that the Hartmans did not acquire the strip of land by adverse possession because of because it was de minimis and permissive. Well, 2 months after deciding Hartman, the second department decided Hogan versus Kelly. All these cases are in your materials. And in Hogan versus Kelly, by the way, the Hartman's claim, adverse possession claim, ripened in 1997. So the old law, should the old law have applied? It already ripened. Shortly thereafter, the Hogan versus Kelly case was decided by the second department, and their claim ripened in 2006, and they used the old law. 2011, the third department, confused by when it should apply the old law. And in 2009, the fourth department, confused by when it should apply, which law should apply, decided what Franza versus Olin, and who Franza, the plaintiff, cultivated the property for over 30 years, mowed, landscaped, erected a shed, and the lower court deemed these acts to be de minimis. The appellate division said, no, you cannot apply the new law to this because it's already ripened. There, you know, where title has vested by adverse possession, opined the appellate division, it may not be disturbed retroactively by a newly enacted or amended legislation. So now all the appellate divisions are everywhere. We don't know how to apply this new law. And so along comes the Court of Appeals in Becker versus Murtaugh. And this deals with owners of leasehold in Oak Beach. Becker right here, had owned his property for over 30 years. Murtaugh was a purchaser in 2004, or a leasehold purchaser in 2004. So Becker builds this dock and boardwalk, and allows, prior to even Murtaugh taking title, allows Murtaugh to, the predecessors in interest, allows them to use the boardwalk and the decking to reach the dock. He also allowed for the neighbors behind, the neighbors to his left, and the neighbors way behind up here to use his boardwalk and his dock. At the time that he built his dock, the predecessor in interest to Murtaugh and Becker believed that he owned the property upon which the dock sits. About 1984, prior to Murtaugh taking title, it was discovered that by a survey, again, we don't know why the neighbor, Murtaugh's predecessor in interest, conducted a survey, but the survey showed that, in fact, Becker built the dock and a portion of the dock and the deck onto Murtaugh's property, or the predecessor, Murtaugh's predecessor in interest property. So Murtaugh, when Murtaugh took title, Becker said, "You're not allowed to use the dock. I don't want you using the dock or the deck." So Murtaugh then brings an action. Becker brings an action for adverse possession so he can be declared the owner of the land upon which the dock sits. And the Court of Appeals, so obviously the adverse possession claim ripened prior to the amendment to the statute. And the Court of Appeals finally spoke on which law should apply. So the Court of Appeals said, if the claim ripened prior to 2008, July 7th, 2008, the old law still applies. Any claim that ripened, adverse possession claim that ripened post July 7th, 2008, the new law applies. So we think we have a solution to the issue of this. Actually, there was no issue, to be honest with you. In looking at the case law now and then, there was really no issue with the adverse possession statute. This really was a great lobby job by the Prisbilos, because the adverse possession statute, while it was barbaric in nature, was very clear in terms of what was required to show title by adverse possession. Now it's kind of murky. It's kind of murky. And I want to just give you, let me just make sure I have the time here. Okay. I just want to give you an example of the things you have to consider in trying to determine whether an adverse possession claim can actually survive. I had a student, one of the attorneys gave me a call and ran this scenario past me. And this is actually a case that's happening right now. It's currently in discovery, but I thought it was a great case to kind of put everything together to show how adverse possession claims are kind of not so easy at this time to get through. So we have two parcels in the city. We have parcel A. This is about a 70 by 25 piece of property that is owned by A LLC. And we have parcel B, and this is owned by B LLC. Parcel A purchased, A LLC purchased back in 2002. And prior to the predecessor in interest to parcel A had owned it since 1998. So 1998 to 2002 is the predecessor in interest. Parcel B, and I'll show you why that's a bit of a, an important piece of information in a little bit. But parcel B was purchased after parcel A by B LLC in 2005. So the issue was this little fence here, right? This little fence was removed here in the second circle by B LLC about a year after she took title, saying that, I don't want this fence here because it's an eyesore and it's an eyesore and I don't like the fence. So obviously the fencing was placed where it was placed because of the sharing of the party wall. When you have such tight quarters in the city, you rely upon the party wall as the boundary line, right? Well, BLLC claimed that that was her piece of little sliver of property that the fence sat on. And ALLC claimed that that fence was her property. And if it wasn't her property, she lay claim to that piece of property by adverse possession. And we're talking 2 inches, 3 inches here. So one of the interesting things that I found with this case is this. So BLLC approached me and said, "Hey, so what can I do here?" And I looked at the survey. There was no exception in the survey with respect to the fact that this thing was that she was out of possessed her land. Okay, she didn't. Or it didn't show that the fence was parcel B was out of possessed their land. So it was a little bit confusing in terms of why a LLC thought that she owned the sliver, right? But party walls, that's what we have to rely on in the city. So in order for parcel A LLC to actually prove her adverse possession claim, because she started owning in 2005, she doesn't have the benefit of 10 years. In order for her to prove that, she's going to have to go back to her predecessor in interest because he has owned since 1998. So he would have had the adverse possession ripened already. Or even, and that she'd had to look through the history books to determine how long this fencing has been up. So in order for her to gain any title to that sliver of property prior to the amendment, she would have had to dig very deep in order to find the 10 years. And her 10 years was the issue. She would have had open, notorious, hostile, because the fence has been up there for years. So she would have had the claim, but unfortunately, she doesn't have the benefit of time. So she's actually looking at this point, and she had to go back and find the prior owner. And what if the prior owner was dead? And what if was the prior owner a full-time owner at that in that parcel during the time that he was there? So all these questions had to be answered by the new owner. So interestingly, if this ripened post 2008, then that fence, right? Is that de minimis? Is that enough for a de minimis encroachment? I think so, but if it was, you're talking about the city. Is an inch or 3 inches where you have a 70 by 100 piece of property, is 3 inches de minimis in the city? It could be de minimis in an acre worth of land. Yeah, if you had a piece of property where there's a 3-foot encroachment or an inch encroachment on an acre, I would think that's de minimis. But in the city where your every little inch of property is important, not so much, right? So this de minimis standard is really asking not only underwriters, but you as attorneys to determine whether or not something would be considered de minimis. And I think that is going to lend itself to really tough negotiations, right? Because if you come to me and say, look, I have a fence and it looks like it's been, it was prior to 2008, it's not the de minimis standard that applies, right? It's the old law that applies. So, this de minimis standard only applies for anything that is post 2008. Okay, so for boundary lines and boundary line variances, we need to ask the questions. How long has this fence been up? Okay, it's important because we need to know which rule to apply. Prior to 2008, post 2008. Who erected the fence? Because that lends to, was there a taking? If your client is the one who is the adverse possessor and is the one that erected the fence, then that's hostile. That's actually a taking, and you can gain. That's one of the elements that you have a check mark for, right? You met an element. How's the relationship with your neighbor? Because this is usually how, obviously, most of these adverse possession claims start, is the neighbor gets upset. You go back to the neighbor and say, oh, I didn't realize the fence was, off my property line or not on my property line. I'm out of possession about 4 feet of my property, and the neighbor has no idea. The neighbor thought that's where the property line was. You go back to the neighbor and the neighbor's upset. Now the neighbor's upset. And now this could be the start of a really ugly war, right? So how's the relationship with the neighbor? Is the neighbor cordial? Is the neighbor nice? Is the neighbor, because it all depends on how this neighbor is as to whether or not you're going to get a boundary line agreement, or whether or not they're just going to go back and say, I'm going to start a court action and I own your piece of property through adverse possession. Does the owner have access to his out of possessed land? Again, that shows if you can show that there's some sort of opening in the fence or some sort of way to get to the out of possessed piece of property, then it shows consent. Your boundary line agreement should really be tighter and make sure that consent, permission, or a cordial relationship rebuts the presumption of hostility. In these two cases, once you have title about adverse possession, any fence affidavit that says I lay no claim to this piece of land is not going to rebut your admission, a title that you've already acquired by adverse possession. It won't destroy it. So these two cases are actually in your materials. One's a first department case back in 1920, and it was followed more recently by All versus Jackson, which is a 2000 case. So I suggest you look at that and make sure that your fence affidavits are, your boundary line agreements are consent, permission, or cordial relationship instead of I lay no claim to this piece of property. So I'm going to give you the code. I'm going to leave it up here for a few minutes. For those who are just on the phone, the code is hostile, H-O-S-T-I-L-E, hostile, H-O-S-T-I-L-E. You're going to need a copy of this. You're going to need to put this down on your affirmation. So please make sure you have the code. For those of you on the phone, it's hostile. Okay, so let's put this all together. I know it's confusing, but hopefully now you know both old law and new law applies. If any of your adverse possession claims or your out of possessions ripened post 2008, that's when you can apply the de minimis standard. Okay. Prior to that, if your claim ripened prior to 2008, then the old law still applies. Please be mindful of the fact that once you've met all the elements of adverse possession, you have title. Okay, you cannot disclaim title once you have met all the elements and the statutory requirement for time. So it's not a right of action, it is title. Your boundary line agreements. Please use any use or possession by me and my predecessors in title of the strip of land between the boundary line and fence has been permissive, has not been exclusive, and has occurred only in the spirit of cooperation among neighbors, because this is the main way you will likely defeat a claim for adverse possession is the hostility portion. If possession has been with consent and a cordial relationship, then that element will not be presumed. And usually that's the element that is the easiest to presume by the court. So if you don't have it, if you have consent, then you don't have the hostility portion. Very important to ask about the encroachments. Do ask about encroachments. Who put it there? How long has it been there? How's your relationship with your neighbor? And one of the things that I think everybody's forgetting to do these days, and it's not really a forget, I think it's more like an accommodation to the people who are purchasing, is we don't recommend surveys anymore. Look, if your survey is greater than 10 years old, get a survey. And 10 years is actually even a long stint without having a review of what's on the property. At the very least, if you have a 10-year survey, somebody has to do some sort of inspection just to see if anything new happened. But, you know, a lot of the issues here, as you can see, was as a result of not having a survey at the time of the purchase. And I think a lot of these adverse possession issues will be relieved if you just obtain a survey. A Okay, so I'm going to try and address some of the questions we have.
Yeah, so I've been trying to keep track of some of the questions. The first one I have is there a minimum distance to avoid an agreement or an affidavit?
If you're talking inches or a foot, I think you can, I don't think anybody will start an action for a foot of out of possessed land. Inches, definitely not. And it also depends on where you are, right? So if you have a piece of city property, as I discussed prior, it's tough to say that an inch is not important to the owner. Usually inches in the city is a big deal because, you're on a 70 by 100 piece of property, right?
Right. So a few questions had to do with, is there a de minimis measurement? So you're saying that there's not?
No, unfortunately, the courts have not interpreted. I've looked into actually cases post 2008, and many of them have been decided based on the old law, because while they are post 2008, many of these cases ripened before 2008.
Mhm.
And any of the ones that do ripen post 2008, the court is finding other means by which to dismiss the case. I have not seen an adverse possession awarded in post 2008 cases. It doesn't really address the issue of de minimis. It's usually thrown out because they think they didn't meet the 10-year requirement.
Okay. Can you adversely possess public land?
That's a municipality. You can, but it's very difficult. If you leave your email, I will get you the case law for that specifically, but on a general basis, it's very difficult to adversely possess a municipality's piece of land. It usually centers on whether that municipality owned it as a municipality and not as sort of like this a corporation, like in a different capacity than the municipality.
Okay. If there's a wooded area on the other side of an out of possession strip, would you omit that?
I would be more apt to omit something like that if it's a wooded area, because there's really no way you can cultivate that, even though it's substantially enclosed.
Okay. If the fence has been standing with no issues, then has it been deemed to be standing with consent and then therefore is not hostile?
No, that's an interesting question. I've not seen any cases like that, but that's an interesting point. The ones that I did see, the ones that have fences that were erected by the adverse possessor, had the fence standing, and the new owner was the one who brought by adverse possession, tacking on from the prior. And I can tell you that the court in that held for the one who erected the fence as an adverse possessor because they met the requirements. So it's not a matter of no one saying anything. So it's really up to the owner of that out of possessed land to do something. But anytime a fence goes up, you should be, as the owner of your property, according to the case law, you should be very vigilant to ensure that that fence is on the line. Because if you're not vigilant, that means your negligence in not being vigilant is not going to be condoned by the courts, right? That dates back to 1800s, that first Court of Appeals case I was talking to you guys about. So I don't know that is going to change. So just because a fence goes undisturbed, nobody says anything, doesn't mean that someone in the next chain and someone in your chain can't come out and claim adverse possession.
Okay. I'm just trying to follow some. So does that mean if you enter into a boundary line agreement, a provision should state that the past use was with consent? Would that suffice?
Yeah. Yeah. Yes.
Can you claim adverse possession regarding a property owned by a state agency? Would that be some?
That's the same as the municipality.
Yeah.
Again,
Okay.
I have the case law to that. If you want to give Diana your email, I will be happy to send you.
Okay, I'm going to get to one last question. So we end around 2. If the adverse possessor puts a fence that encroaches onto the parcel, but it was placed there because rocks or something similar would have impeded the placement of the fence, does that meet the criteria of hostility?
If it was placed there, well, it all depends on what you can, again, this is all dependent on what you can prove. We can surmise that that's the reason why the fence was put there. But unless you have the consent of the neighbor, or unless you have the consent factored in, it doesn't necessarily mean that that's the reason why you put the fence where it is. So consent is huge. Even if you get the boundary line agreement from the neighbor that just says, I've consented to the fact that, the fence is where it is, even though, you're out of possessed a portion of your property. If you could get just that portion, it's with consent and it's been cordial, and you can add, I don't lay any claim to this land, but I think that's where most of the neighbors get a little upset at signing anything, because once they see I lay no claim to this land, that means they're giving away something or something. You know what I'm saying? So
yeah,
you don't want to have to kind of give them that. So if you just put, I consented and our relationship has been cordial in terms of the use, I think you're good with that.
Okay. Thanks again for a wonderful CLE, and thank you all for attending. Just as a reminder, you can send your affirmation back to me. We'll have certificates out to you within the week. And, after the close of the lecture this afternoon, I'm going to resend all of the materials to anyone who was in attendance. And thank you again, Toni. I really appreciate it.
Thank you. I'm glad I was able to do it for you.
Thanks,
Until
everyone.
next time.
Until next time.
Thanks.
Thank you.